We do have a public hearing this evening, and we don't have these very frequently, so we might sort of plow through it a little bit here. But I appreciate everyone coming out for it tonight. This is a hearing on the appeal of the Board of Zoning Appeals decision in case number BZA 25-007, which approved the zoning administrator's decision that the zoning code does not permit keeping chickens on residential properties. First, the city staff will make a presentation. Then the appellant may present. Presentations will be made from the lectern right there. Witnesses, if any, will sit in the witness box. That's this one right here, located to the right. And I'll call you up when it's time to sit in the witness box. All persons giving testimony of evidence will be placed under oath and be subject to cross-examination. If you have documents that you want counsel to consider, you may submit those to counsel at the end of your presentation. After the presentations, counsel will take comments from those members of the public who are present and wish to be heard. Comments will be limited to 5 minutes per person. Persons commenting will be placed under oath and be subject to cross-examination. Since City Council is sitting as judge and jury in this appeal, City Council will not respond to questions or make statements regarding what is presented tonight. Do not direct any questions to City Council or expect City Council to comment on the appeal. The public hearing will then be closed. This hearing is being recorded, and the recording will be the official record of the hearing. Please speak clearly and into the microphones. If needed, City Council may continue the hearings to a future meeting. Now, all persons wishing to speak tonight regarding the appeal should stand, raise your right hand, and take the oath. Do you swear or affirm that the testimony you give before City Council will be the truth, the whole truth, and nothing but the truth, under penalty of perjury? You may be seated. At this point, Mr. Holmesy will make a presentation on behalf of city staff. Mr. Holmesy, you may proceed.
Thanks.
Welcome.
Hello. Thank you, Mayor. Good evening, Council. I'll give a quick overview of the subject appeal and a quick overview of what was discussed and what staff determined to be the pertinent evidence discussed at the board.
Could you speak up a little bit, Ryan?
Yeah.
Thank you.
I'll give a quick overview of the case, as well as a quick overview of the pertinent evidence that was discussed at the Board of Zoning Appeals meetings that we held on this. If you have any questions, feel free to ask me. Just to give a quick overview, the subject appeal deals with the keeping of chickens. And it is an appeal of the decision of the Board of Zoning Appeals to uphold the zoning administrator's interpretation of the Kettering zoning code with regards to chickens not being considered household pets in the city of Kettering. So, a quick overview of the appeal process. The zoning administrator is empowered to interpret and enforce the zoning code. That authority is given in section 1131.06 of the zoning code. Of course, when you're interpreting codes, there's always some risk of disagreement. And if there is disagreement, residents are able to appeal the zoning administrator's interpretations to the Board of Zoning Appeals, and that is described in section 1153.14. The BZA, if in a case is appealed to the Board of Zoning Appeals, the BZA will hold a public hearing. And the BZA will make a determination based on the evidence presented by staff and the appellant at the public hearing. If staff made an error in any written order, requirement, decision, and interpretation, or judgment or determination. If there's disagreement with the BZA's decision, individuals may then appeal that to City Council, and that's why we're here tonight. Council's role is to determine if the BZA made an error in their written decision based upon the evidence discussed and presented at those meetings. And the council package that went out included the staff reports for the BZA meetings, as well as a memo covering the meeting this evening. So this is not a meeting where additional evidence should be presented or considered, and the decision should be made based upon the information the BZA had when they made their decision. Quick overview of the timeline of the appeal. This particular case started in April earlier this year when our community service specialist received an inquiry asking about whether or not chickens are permitted to be kept on residential properties in the city. That inquiry triggered a visit to the property where chickens were discovered. And then on May 9th, the notice of violation was sent certified to the owner of record of the property, that property being 817 Kenosha, regarding the keeping of chickens on the property, which is not permitted per section 1139.04.6, the keeping of pets and animals of the Kettering zoning code. There's some correspondence between the property owner and the code enforcement officer for that area of town in the middle of the month. Based on those discussions, it was determined that the property owner wanted to appeal the interpretation of the code. That appeal document was submitted on May 30th. And that appeal argued that chickens are permitted in Kettering as household pets as the code is written today. And then after we got that appeal, we set the public hearing for the July 14th Board of Zoning Appeals agenda. They held a public hearing that evening. At that meeting, there were some questions for staff that they wanted more information on, so they motioned to continue the case until the August 11th meeting. And at the August 11th BZA meeting, the BZA ultimately motioned to uphold the zoning administrator's interpretation of the zoning code. Sorry, was
Are you finished with the presentation?
No.
No.
Not yet. And then following that meeting of the Board of Zoning Appeals, the appeal of the BZA decision was submitted to the Clerk of Council on August 22nd. And that appeal was placed on tonight's agenda, and we are having the public hearing tonight. So a quick overview of what is not being decided this evening. We're not deciding whether or not the city should or should not permit the keeping of chickens. We're not deciding whether or not chickens cause odor, noise, or other issues. We're not deciding whether or not our residents support or oppose the keeping of chickens. And we're not deciding whether or not the appellant is deserving of keeping the chickens. What is being decided this evening is whether or not the BZA made an error in their written decision with regards to the keeping of chickens based upon the evidence they were presented at their meetings. So there's a couple applicable zoning code sections that relate to the keeping of animals in general. The first, which I referenced earlier, is 1139.04.6, the keeping of pets and animals. And that section references section 1159.02 of the zoning code, particularly the definition of household pets. So section 1139.04.6 reads as follows. The keeping of animals is permitted subject to the following conditions. A, the only animals that may be raised, bred, or intentionally kept on any lot are those referred to below. Number one, household pets as defined in section 1159.02 definitions may be kept or fed on a premise provided such animals satisfy the following conditions. They are not maintained for any commercial purpose, and they are not maintained in such numbers to constitute a kennel as defined in section 1159.02. When the code was written, there were a couple of carve-outs that were created related to the keeping of somewhat unique animals as well as the keeping of some insects. One of those is the keeping of horses and ponies, which are permitted as long as the property meets the requirements of section 1139.04.9, and beekeeping may occur on premises subject to the provisions of section 1139.04.2. On the screen now is a screenshot from the zoning code of that section. The graphics on the right side were added as a part of the 2015 code rewrite in order to add clarity to this particular interpretation of the code, just intended to add clarity. And in the packet that went out, the ordinance that adopted the new zoning code, as well as an excerpt of that page, were included in the packet. The definition of household pet in section 1159.02 is household pets are any dog, cat, or other species of animal, fowl, fish, amphibian, or reptile, which species is commonly deemed in this city to be tame and domesticated, or that is commonly accepted in this city to be as a pet kept inside a residence. That last sentence was also added as a part of the 2015 zoning code amendment, that a household pet is not kept for food production or agricultural value. So the ultimate question is, are chickens kept for food production or agricultural value? And staff believes the answer is yes. City Council has had some input on this item, either through presentations at work sessions or through memos that were sent out, kind of highlighting what the staff interpretations of the code are now as they relate to chickens in September of 2014, in July of 2016, in September of 2020, in May of 2024. In those discussions, there was not a push to change the code to allow the keeping of agricultural animals on residential properties in the city. Again, just a quick summary. What is under consideration this evening is, did the BZA make an error in their written decision regarding the keeping of chickens based upon the evidence provided in the appeal documents and at the public hearing? And why is this working? And again, are chickens kept for food production or agricultural value? Staff believes the answer is yes. And that concludes my presentation.
Thank you. Do you have any other exhibits that you wish to have entered into the record?
I just printed out the reports that were included with the council packets that went out.
Okay. Give me this to say so. Okay. And you are now finished with your presentation?
Yes. Are there any questions?
Mr. Combs, do you have any questions? You do? Okay. I'll ask Mr. Holmesy to go into the witness box. And you may come to the lectern, and you may ask your questions from the lectern.
Did the BZA have the full entirety code to review during that BZA hearing?
They had the pertinent code sections. It was included as an attachment that went out with the board packet.
So that will also include 1139 and enactment and interpretation of the code?
Which section?
1131.01, which is enactment and interpretation. John, one of the board members, referenced 1131.
Yeah, that was referenced at the meeting. I don't believe that section was included in the attachment that went out.
And 1159, rules of interpretation and definition was also included, correct?
That one I believe was.
That's all I have.
I think if Mr. Cited has a question for Mr. Holmesy, now would be an appropriate time for him to ask that. And then Mr. Holmesy would have an opportunity for rebuttal after the questions from council to him.
My question is, what fowl would be considered a household pet? Are parakeets, budgies, lovebirds, are those considered fowl in our code? Or in what situation would a fowl be accepted as a pet?
It depends on what definitions you look at. We don't define fowl in our code. There are some definitions that are admittedly a little bit older definition of fowl that included all birds, or any species of bird, but they particularly are focused on hens and things of that nature. But I believe that was included in the code just as with the intent to refer to birds in general. So parrots, parakeets, indoor caged birds, and things of that nature.
Any other questions? Council? Okay. You may now step down.
Well, did Mr. Holmesy have anything in rebuttal?
He
Not at
answered
this
the
time.
question. Yeah. Mr. Combs, please proceed with your presentation.
I do have a packet at the end of my presentation to present. Packet has details of my speech, some other things that I will be reading. Good evening, members of the board. My name is Todd Combs, and I'm here to appeal the prior decision of case BZA 25-007 and the notice of violation V25-1509. I would like to thank you for your time and your considering this matter seriously. I have submitted a detailed written appeal packet. Tonight, I will summarize the key points. My focus is simple: the code as written, the errors that were made in applying it, and the legal proceedings that show why this decision must be reversed. Thank you for all you do and your willingness to listen with open minds from your residents. I'm a long-standing Kettering resident that left for the military and moved back when it was convenient. And I boast about this great city every time I get a chance. I tell you a little quick motto that I tell my son Seth: you don't know what you don't know, and you only know what they want you to know. If you want to know it, if you want to get ahead in life, you need to research yourself to truly know. I'm here tonight to stand up for my rights and liberties, and what the city has authorized for years to keep my household pet fowl. I first want to share an agreement with the city. Numerous times, City Council has discussed authorizing chickens and made no amendments or excluding the fowl in the code for numerous years. I stand behind that. I'm not here to argue for chickens or wild animals. We live in a residential area, so I agree we should not permit wolves, foxes, coyotes, chickens, Bengal tigers, Canadian geese, mountain lions, or any other dangerous beast on our properties. Yet I appreciate the city voting numerous times to allow for the domestication tame versions of these beasts, such as dogs, cats, and fowl, which is, I'm going to read 1131.03, which is rules of construction from the City of Kettering Code. Interpretation and application of this zoning code are for the basic and minimum requirements for the protection of public health, safety, comfort, morals, convenience, prosperity, and welfare. The zoning code shall be literally interpreted in order to further its underlying purpose. The meaning of any and all words, terms, phrases of the zoning code shall be constructed in acceptance with Chapter 1159, Rules of Interpretation and Definition of the Zoning Code. The zoning code contains numerous graphics, pictures, illustrations, and drawings in order to assist the reader in understanding and applying the zoning code. However, to the extent that there is any inconsistency between the text of the zoning code and any other graphic, picture, illustration, or drawing, the text controls unless otherwise provided in the specific section. The zoning code text controls any tip or commentary. The zoning code contains numerous tips, sample calculations, reminders, and other commentary with margins. These tips and commentary are provided for the assistance of the reader, Kettering resident, and are not mandatory. Section titles are offered for convenience only. I do not want the code to be changed or amended. I just want the written code honored in which my city council has voted for years. They understand what I just read because they voted on that same provision in the code for years also. At this time, I would like to take a note for the record that there wasn't a discussion regarding Shelley Davis's investigation or determination if my pets were a wild chicken, a farm animal, poultry, or a household pet fowl. I also want to point out she never went into my backyard to see for herself. How could she know if my pet fowl are indeed wild chickens as they're playing the game Catch the Worm on the screen there? That's me throwing a ball to my pet dog, but I don't have a pet dog. I got pet fowl. I also noticed there was no discussion on the investigation from the city inspector planner Doug regarding his interpretation of pet fowl, yet he decided to have them listed as the wild beast chicken. For the record, this city does not want wild animals in their city. I have witnessed a company that will drive out wild Canadian geese from the different ponds within our city limits, yet they keep the waterfowl duck, the tame domesticated version. We all remember going to the Ducko Park for fireworks, and I love my fireworks. And we all had to avoid the droppings from those Canadian geese when we went there. The city discussed it and paid a company to remove these wild geese. I've talked to the guy. However, they allowed the domesticated waterfowl to remain and stay, as people love to see them. So the city does authorize fowl within its limits, even to the point they voted numerous times to allow residents to own that fowl. Every definition of fowl comes down to this. It's the wild chicken. You can see the date. The first date was August, and this is the second time I bought them on the screen. Every definition of fowl comes down to this. It's the wild chicken, which is the domesticated tame version, which is allowed. There is poultry, which you'll find that as the farm animal in section 618, which is bred over the years to produce bigger meat places. And then you have the fowl that's tame and domesticated. As you can see in my slideshow, I have numerous pictures of friends and family and ourselves interacting with our pets. I was looking forward to the discussion at the zoning board hearing on August 11th, even after the July 14th hearing was extended. However, unfortunately, that discussion never came. July 14th, the 1 hour, 14-minute, 40-second mark. You can find that. The new chairperson informed us she had reviewed all the notes and all information provided, yet some things were left out. One of the board members asked about court cases. I brought a court case, and I wasn't allowed to present it. Did she need to understand the whole zoning code as chair of BZA, yet was my side even provided to her? She never said that. Why did the chairperson not correct the city on not including what the other household pet, other species of animal definition was when asked? She had no questions for either the city or me. In fact, she wanted zero discussion about the actual case. After the board said what they needed to say, no more discussion. I thought the board, like you guys are, was the judge. August 11th, 1 hour, 57 minutes, 48 seconds. Which is again why I've been so frustrated through this process and quite honestly what disappoints me. If the city truly wanted my particular type of household pet fowl removed, they could have simply done that numerous times. Instead, they added a deterrent in a form of a graphic to a city code with no description, and they call it the lawful code. I've already read Chapter 1159, Rules of Interpretation and Definition. For the purpose of this zoning code, the following terms, phrases, words, and their division shall have the meaning as set forth hereon. What's not inconsistent with context. Words in the present tense include the future tense, and words in the plural manner include the singular number. Words in the singular number include the plural number. Words in the feminine include the masculine, and any of the masculine include the feminine. The words shall and must and will are mandatory, and may is permissive. Words not defined shall be given their common and ordinary meaning. I apologize for reading something you guys already voted on and understand. Reference to chapters and sections or subsections are useless unless otherwise specific. References to chapters, sections, or subsections of the zoning code. Defined terms remain defined terms whether or not it's capitalized. The text of this section shall control captions, titles, and maps. Within the zoning code section, prefix, purpose and findings, and the purpose and intent are included. Each purpose statement is intended as an official statement of legislation findings. These statements are legislatively adopted, together with the formal text of the zoning code. They are intended as a guide, administration, and the interpretation of the zoning code. Again, the BZA board and council tonight. And shall be treated in the same manner as other aspects of legislation. The written code overrides the graphic. During the hearing, the city provided no evidence that I, Todd Combs, had been in violation of this code. It was all opinions, and we deemed it so. But the code's law. Thank you, board, for taking the time to hear my appeal and my story. These pets mean so much to me and my family. I cannot overstate this. I'm a disabled U.S. combat veteran who suffers from suicidal thoughts. To have gotten my pet fowl. My fowl lifts my spirits as well as those of my family members. I tend to be a private person, yet I have to share my story with the community as I believe my rights as a Kettering resident are being violated. And that's not fair to me, my family, or any other Kettering residents. When I looked into getting my pets, I searched and I found the frequently asked question page in Kettering that said no chickens per Kettering code. Like I said, I love fireworks. And after the state of Ohio authorized fireworks in Ohio, City of Kettering did not. The City of Kettering has home state rule. Yet if you search, when you get that code, it will clearly tell you what code you're violating if you set off fireworks in Kettering, but yet not for chickens. So me being me, you don't know what you don't know until you research it yourself. I wanted to find that code, and I never found it. I even asked Doug for the code. He never provided it to me. But I did find 618. I opened up the website, clicked on the code, downloaded the code, and followed the instructions on how it works, starting from the top. I read about the zoning codes. I skimmed down until I got to 11390406, keeping of pets and animals, and I saw a picture of a rooster. Because remember, it's the interpretation of the reader at the time. I thought, due to most places don't want roosters. Then I skimmed down 115902 definition notes. I passed a lot of graphics with titles and descriptions, yet none for that rooster and pig. And then I got to 115901 rules of interpretation. Words with specific defined meanings are as follows. I went down to household pets and passed by dwelling and evergreen. And then got to household pets. I saw fowl. And I read no pet for food source. Then I went back to the pictures and I saw pig. Oh, that means I can't keep swine or poultry because those are the farm animals that the city of Kettering has already authorized us to own and harbor, but we can't have that type as a pet. Or it means no roosters. My pet fowl are kept for companionship because my family has issues with other pets like dogs and cats. And frankly, fish are boring. I'm kind of a hyper person, and my fowl are a perfect pet for me. I don't keep my pets for a human food source, nor an ultra culture value. I met the conditions, so I went out and bought my Ohio native baby fowl chicks. I was shocked to find that Officer Davis stopped by and told me I was breaking the law. I was a common criminal. When I told her they were my pets, she said they can't be pets. And then shortly after, I got a violation in the mail. I emailed Doug 3 times, and I asked him for the code I broke. And he informed me I informed him they are my pets. Instead of helping me, he used the threat of fees per his voicemail. July 14th, the 1 hour, 10-minute, 48-second mark. The powers and the duties of the zoning administration. The zoning administration shall be appointed by the city manager of the City of Kettering and shall enforce the provisions of this zoning code and interpret the zoning map and the text according with the provision of this zoning code. Notice it didn't say pictures or graphics. I thought for sure Doug would tell me. He's the person that residents go to. He talked on the phone after my first email, and all he did was tell me he skimmed my email, but I had to pay $250 non-refundable fee. That fee is up to $700 now. This is how much these pets are worth to me. I have asked him for a ticket if I'm breaking the law. Again, he left me a voicemail, said there's a misunderstanding. If I don't comply with his order, I took that as a threat. Yet I have household pet fowl, not chickens. At no time did anyone from the city inspect my pet fowl. How can you just say they are wild chickens if you don't investigate? The code permits fowl as pets. Kettering Code 115902 defines household pet as any dog, cat, or other species of animal. Fish, fowl, the frog one, and this one's special, reptile, which species is commonly deemed in the city to be tamed and domesticated, or that is commonly accepted in the city to be kept as a pet. I'm not going to insult your intelligence. All that last verbiage only applies to reptile because city council has already voted on the wild beast they determined to be tamed and domesticated. And again, the wolf becomes the dog, the Bengal tiger becomes the cat, the chicken and the geese become the fowl. This is very clear. The ordinance expressly includes fowl in the list of animals that may be kept as pets. Every authority, I can't pronounce it, but definition of the word fowl includes chickens. Merriam-Webster defines fowl as a cock or hen or the domestic chicken. The Oxford English Dictionary defines fowl as birds of the order, and again, that's too confusing for me to say, which are chickens, ducks, geese, quail, and turkeys. There is no definition anywhere that of fowl that excludes the wild chicken. Therefore, the only way the board might have reasoned that these fowls are not included if they were not deemed tamed or domesticated. But as the documentation I provided shows, wild chickens, fowl have been considered tamed and domesticated animals for hundreds of years. Veterinarian authorities, researchers, and national organizations all confirm this. Perhaps the phrase, or that is commonly accepted in the city as a pet, was used as justification. But that would also be an error for 2 reasons. First, the word or means that only one of the conditions must be satisfied, either tamed and domesticated or commonly accepted. Second, the ordinance provides no definition on what is commonly accepted in the city as a pet. In such cases, generally accepting professional standards must apply, and by those standards, there are ample evidence from veterinarians and the American Veterinary Medical Association organizations like PetMed and the Association of Avid Veterinarians that chickens are indeed recognized and accepted as pets. So under both plain meaning and professional standards, my hens are household pets within the scope of 115902. Errors in August 11th decision. In the August 11th decision, the board concluded that chickens are ultraculture animals and not pet, which was an error for several reasons. First, the ordinance already excludes animals kept for food production or ultraculture value. My hens are not kept for either purpose. They are pets. If I was keeping poultry for ultraculture purposes like meat or eggs, I might concede the assumption that they fall outside the pet definition, but that is not the case. I provided ample evidence that my hens are kept solely as pets, while the board has failed to provide any evidence that they are not. Second, the board relied on captions and graphics added in 2015, but the code itself states the words of the section shall control over captions. Reliance on a caption instead of the words of the ordinance was a legal mistake. 1131.03 and 1159.01, July 14th hearing, 1 hour, 18 minutes, 18 seconds. Third, the board compared hens to cows or bulls being kept as pets. That analogy does not hold. Hens are small, quiet animals, comparable in sizes and impact of parrots, rabbits, or ferrets, all which are permitted. Well, I don't know about the ferrets. Fourth, no reports from Shelley Davis and Doug Denise to issue the V25-01509. Fifth, per Ryan, this violation was the removal of chickens, not kennels. I do not have chickens. I have household pet fowl. Finally, even within your own proceeding, board member Kim Haverstack referred to my hens as pets during the July 14th hearing, 1 hour, 25 minutes and the 25-second mark. That acknowledgement aligns with the plain meaning of the ordinance and mentioned after August 11th hearing, he used pictures, 2 hour, 0 minutes, 50 seconds. Ohio case law requires favoring of the property owner. Here, the ordinance does not say chickens are prohibited. Instead, it says household pets include fowl. Wild chickens become the domesticated fowl. If there's any doubt, the immunity must be resolved in my favor, according to Ohio Supreme Court. The violations issued against me allege I was keeping animals in violation of the zoning code. At no point did the city provide factual evidence that my hens were being kept for food production or ultraculture purpose, or that they created a nuisance. I showed them how I dispose of the eggs so they don't smell in the trash can. Now I got to put them in the kitchen sink because I found out I was using it as a food source for animals and not humans. Because I want to be honorable and do the right thing. The city's case relied mostly and usually on assumptions. The assumptions that chickens are always ultraculture or that they must be livestock. Yet that is called poultry, not fowl, as found in section 618.14, wild or exotic animals of the City of Kettering General Offense Code. But assumptions are not evidence. The code requires proof that an animal is not a household pet or that it's being used for a food or an ultraculture purpose. That proof was never offered. I have a barn in my backyard. Does that mean I live on a farm now? That's what you're telling me. On the contrary, I have submitted letters of support from my neighbors, documentation, veterinarians, authoritative research showing that hens are commonly recognized as pets. These are facts. The board's decision by contract rests on opinions and analogies. That is not significant grounds to uphold a violation against a citizen. Reliance on a caption, opinion, and process errors. A second major issue is the board's decision was built on reliance on captions and opinions instead of the controlling text of the ordinance. July 15th. 1 hour, 17 minutes, 12 seconds. August 11th, 1 hour, 55 minutes. The code itself states the words of the section shall control in two places, not captions. Yet in my case, captions and graphics added in 2015 were treated as if they carried the same weight as law. This is not consistent with the rules of statutory interpretation. If officials had in fact intended to ban pet chickens or fowl, they could have amended the ordinance itself, eliminating any question or ambiguity, but they did not. The city's even provided how many times they've discussed, and nothing's been done to the code. Yet to me, that picture was a rooster. Or could it mean not to use a food source, since that graphic of a pig was also added? Yet the city had no evidence of me using my pet fowl. I asked Ryan during the hearing, and both answers were no, prior to issuing the violation. In addition, comments were made in the hearing suggesting that I should have called the city to ask for permission before keeping my hens. With respect, that undermines the very purpose of publishing a code. That code is written so residents can read it, understand it, and follow it. Citizens should not be penalized for doing exactly what the ordinance allows, especially when the plain text includes fowl as a household pet. I did reach out to the city and was told to appeal to the BZA for $250. During the August 11th hearing, it was stated by the city council had multiple conversations on chickens. Yes, we don't want wild chickens in Kettering. City council has voted to protect our residents for years to allow household pet fowl. And since they understand what the verbiage means, I interpret them not making a decision to amend the code, not to exclude fowl like they did in Evergreen pertaining to cactus. Yet in 2015, a picture was added without even talking about it to the public, because it's probably an expensive process to do. Taxpayer money could be utilized at other places. Finally, there were clear irregularities in the process. Testimony relied on personal opinions and assumptions, not the written code. Evidence was introduced by staff after the record had been closed, and a board member specifically referred to my hens as pets. A statement that did not make it into the official minutes, but was captured on audio. Each of these factors further demonstrates the decision was not based on proper application of the ordinance. July 14, 59 minutes, 57 seconds. Fairness, consistency, and rule of law. At its core, this case is about fairness and the rule of law. The ordinance is the same for every citizen. It says that household pets include fowl that are tamed and domesticated or otherwise accepted as pets. That standard cannot be applied differently depending on whether the animal is a parrot, a rabbit, or a hen. To allow subjective preferences to override the plain language of an ordinance is to create inconsistency and uncertainty in the law. Ohio courts have been clear that citizens must be able to rely on the words of the ordinance. If city council wants to prohibit chickens, it has the authority to amend the ordinance. But until then, the code as written must be controlled. My fowl meet that definition of household pets under 115902. That should end the inquiry. In closing, respectfully submit that the violation against me was never supported by evidence, and the board's decision was based on assumptions, captions, personal bias, analogies rather than actual text of the ordinance. The facts are straightforward. The ordinance expressly includes fowl, and every definition of fowl. My hens are tame and domesticated. When I come home from work, I open my gate, and they're right there. First thing, I don't even go see my wife. I go see my pets. I go straight there, and they're waiting by the gate for me. It's so uplifting. That's what my pets do for me. Same thing as when you pull in your driveway and the dog jumps in your bay window, and hopefully they don't break it, and they're wagging their tail, and then you got marks all over the window because the dog's doing that. It's the same thing. My hens are tame and domesticated. They are not kept for food or agriculture. There is no evidence to the contrary. Ohio Supreme Court proceedings requiring meetings to be resolved in favor of the property owner. The decision relied on captions and opinions which the law says cannot override the ordinance text. This case is not about preferences, opinions, or biases. It's about what the ordinance actually says and how Ohio law requires it to be applied. For those reasons, I respectfully ask the board reverse its prior decision and recognize what past city council members have voted on for decades and authorize me to keep my household pet fowl.
I only have one. How many chickens are kept on the property?
I have zero.
Are kept on the property?
Zero. I have 18 household pet fowl.
Thank you.
I actually have two. Did the Board of zoning appeals, ask you questions about where the fowl live? Do they live inside the house or outside? Did BZA ask that?
No.
Okay.
BZA didn't ask me, to my recollection, any questions on August 11th. And Ryan, do you remember, or Tom, they asked, I don't think they asked you guys the questions. They asked city staff. They didn't ask me a single question.
Okay. And did they talk about at that meeting, the definition of a kennel?
Yes, briefly, but it wasn't too much. But again, you have in the kennel definition, I have a great memory, apologize. In the kennel definitions for cats and dogs, and they added the word rabbit. Rabbit is also not found in household pet fowl. But then in number 4, it has other household pets. Again, other household pets also is defined in the city ordinance household pet. Fowl is by itself and was not included in the definition of kennel. In the regular definition of kennel for Kettering, it was an established place used for business. But yet, the Webster Dictionary says a kennel is for a boarding place for cats and dogs. What I personally have, if you want to get silly with it in a sense, is a fowl habitat. It's kind of sort of like an aquarium for fish. If I had 200 fish, do I need a kennel for them? No, because they wouldn't live in a kennel, they would die. So for my particular pet, it's not listed underneath the definition of kennel per code.
I was wondering if BZA, had any discussion about, one of the conditions to have pets is they are not maintained in such numbers to constitute a kennel. And 18 seems to fall above that threshold. So I was just wondering if BZA discussed that part of it.
If you looked at some of the pictures in a very clean sanitary environment, they technically don't even need that to begin with.
Okay, I do have one. The picture of the fowl or the chicken or the hen or the rooster, when did you first see that?
I first saw that in, I want to say, April 2024. Actually May. I joined a Facebook site and learned a lot from different people. And then I took the time to read the code. And I do not process things fast, but I process things. And as I went through and went down the code, when I realized I could own them, it took me about 4 or 5 months. And then I went and purchased them. Because to me, it was a deterrent. It wasn't the code. It wasn't the law. It's a picture. It's the only picture in the zoning code that doesn't have a title, a figure, or anything. It stands out. And to me, that attention to detail that one little detail made it look suspicious to me. And that made me look harder. And then when I saw where it says text control graphics, then that takes that graphic right off the page because the text rules over the graphics.
Okay. Do you have anything that you'd like to add at this point?
No, I just keep honoring what you guys have voted on for years.
And do you have any other exhibits that you'd like?
I will
They have.
pass in a packet.
Okay. Give them to Mrs. Hayslip. Okay. It's now time for public comments.
I am here to voice my support for Mr. Combs' position that his household chickens are indeed pets. I wanted to reference the code specifically, as was repeated a few times, any dog, cat, or other species of fowl, etc., commonly deemed in the city to be tame and domesticated. Fowl is mentioned but not defined. However, this commonly refers to chickens linguistically. In fact, I'm not sure what else it could really refer to. If you say fowl, it's pretty much chicken. And that would, by being in the code, imply that in certain situations, chickens could be indeed considered pets. It also says that any fowl considered in the city to be tame and domesticated. Hens, from my personal experience growing up with hens, can definitely be tame. And in fact, all chickens here are indeed called domesticated chickens. So chickens are inherently domesticated. Because of the or statement after that, city to be tame and domesticated or commonly accepted to be kept inside of a residence. It doesn't have to be in a residence. It just has to be either tame and domesticated or kept inside of a residence. Finally, the household pet is not kept for food production or agricultural value. Based on Mr. Combs's statement in a Dayton Daily News article that I read prior to this, he states that he does not even consume the eggs that his chickens produce. He cooks them and gives them directly back to the chickens. He buys his own eggs. So I don't see a situation in which he uses his chickens in any way for food production or agricultural value. I can't really see him eating them either, considering how much he seems to love them. Finally, I don't believe, as Mr. Combs stated, that a picture of a crossed out chicken is citable or referenceable legislation. I don't think that's valid legislation. I would imagine that the text in the code itself would be the only legislation that you can actually interpret if it doesn't have any kind of title or caption or description. So with that said, the code, any fowl deemed in the city to be tame and domesticated, that all applies. It doesn't have to be kept inside of a residence, and it's not kept for food production or agricultural value. So I don't see any situation in which Mr. Combs's domesticated chickens could be anything other than a household pet.
I'm here in support of Todd. When he informed my mother and I, who live across the street, that he had new pets, it wasn't that he had new farm animals, he had new pets, he had new chickens. And I'm not going to be citing any specific codes. I'm going to be appealing, hopefully, to your better natures and your basic compassionate response that pets are members of our family. We treat them as members of our household. I've never seen him treat these animals as though they were livestock, as though they were something to be consumed, something to be sold. I've seen him treat them like family. My experience with Todd as a neighbor and with his pets has been as such. It has been as someone who is taking care of family members, someone who is incorporating it into the daily life of his children, of his spouse, even of us in the neighborhood, introducing us to his new pets. I do think it's being purposely obtuse to try to say that these are animals that he is trying to make production out of. He has never attempted to do so, as far as I'm aware. He has just opened up his home to more livelihood. That is all I have to say.
At this point, then, the public hearing is closed.